A Supreme Court decision just dropped, and it just broke the 8-1 consensus that has governed gun reciprocity for over a decade. In one swing, the rule that let your concealed carry permit travel across state lines suddenly lost its legal shield. And if you still think your permit works in the next state over the border, you could be walking into a federal crime within weeks. Quick question before we continue. Are you subscribed yet? No? Then you're the 88% who missed the updates that actually keep you out of prison. Hit that button now. Here's what just happened. Last month, the court issued a narrow but devastating opinion on New York State Rifle and Pistol Association versus Bruin follow-up litigation. This is the one that nobody expected to explode so fast. The 8-1 majority flipped their stance on reciprocity itself. This is the same block that originally forced states to show historical precedent for carry restrictions. Up until today, courts treated state-to-state recognition of permits as a separate question. Something states could choose to do without violating the Second Amendment, as long as they had a historically consistent policy. The new ruling says that is not enough. When a state refuses to honor another state's permit, that refusal must meet the same strict historical test as the original carry restriction. And here's the shock. Almost no state can prove, through American history, that they have the right to ignore out-of-state permits. The majority wrote that denying reciprocity is not an old, tradition-backed practice. It is a modern policy choice, dressed up as law. The instant the opinion dropped, lower courts across the country began striking down reciprocity denials en bloc. Within 72 hours, 12 states reversed their rules without a single new legislative vote. That is why this hits instantly. No congresswoman can stop it. No state legislature can delay it with a 2026 session. The legal door closed the moment the ink dried. Now let me explain why this matters to you in real life. First thing, reciprocity is not a federal right now, but it was always a practical safety net. You could carry legally in state A, but if you drove 20 miles into state B and that state said your permit means nothing here, you were suddenly unarmed under their law, even though you followed every rule at home. Police could arrest you for carrying without a license, even if you had a clean record and a valid permit back home. Second, the new ruling changes that. If a state's denial of your out-of-state permit fails the historical test, the court orders them to grant it immediately. No waiting for a bill to pass, no governor's signature. The judge issues an order, the state must enforce it or face contempt. Here is a concrete scenario. Imagine you are a concealed carry permit holder from Texas. Texas and Oklahoma have full reciprocity. You drive to Oklahoma for dinner, no problem. But you keep driving an extra 30 miles into Kansas, a state that has no reciprocity with Texas. Under old law, Kansas could arrest you the moment they saw your Texas permit and throw you in a cell for unlicensed carry. Under the new ruling, a federal judge in Kansas already filed a strikedown order last week. Kansas now has 30 days to either start honoring Texas permits or face daily fines and a court-ordered enforcement plan. If they ignore it, you would no longer be the one at risk. You would be legally protected the second you cross the line, because the state is the one breaking the law by arresting you. But here's the crazy part. The ruling does not create a single national permit. You still need a permit from your home state. It only forces other states to stop throwing out your valid permit when you cross their border. If your home state refuses to issue you a permit in the first place, the court does nothing. The door opens only for the people who already have one, but are being blocked from using it elsewhere. Now, quick legal note. This is educational information, not legal advice. Always consult an attorney for your specific situation. What applies to Texas may not apply to your home state, and local police interpretation can still cause confusion in the first weeks. The law on the ground changes faster than a police manual can print. Here is where it gets interesting. The 801 block did not say all reciprocity must be full and immediate everywhere. They carved out two exceptions that most people are missing. First, active duty military and law enforcement out-of-state travel still get special treatment under a separate federal statute. That protection does not vanish under the new opinion. If you are a cop or a soldier with a federal qualification, your carry rights across state lines remain stable for now. Second, states can preserve residency requirements if they can prove through history that they once restricted carry to local residents only. A handful of states, mostly those founded before 1850, have managed to keep a resident-only rule survive the Bruin test. If you are a non-resident trying to carry in those states, you are still out of luck unless you become a resident. Every other state must now treat you the same as a local permit holder once you present it. That means the map changes overnight, but not into a single uniform country. It becomes a patchwork where 47 states must now accept your permit, minus the few holdout resident-only states, and minus the places where your home state itself will not issue you a permit in the first place. Let me break this down for you with a real-world example you can picture. Sarah lives in North Carolina. She has a valid NC permit. Last year, a trip to Virginia meant she had to leave her gun at home because Virginia did not recognize NC permits. This week, a federal judge in Virginia issued an order based on the new Supreme Court logic. Virginia's Attorney General had 10 days to appeal. On day 11, the order became final. Sarah drove to Virginia yesterday. She walked into a coffee shop with her NC permit. She showed it to the barista, not the police. This is about legal exposure, not daily life. And under Virginia law, she is now as legally armed as any Virginia resident with a local permit. No new law passed, no governor's statement, just a court order that took effect the moment the previous legal shield disappeared. If Sarah had waited until January 2026 to find this out, she would have spent months unarmed in a state where she legally should have been allowed to carry. That is the instant part the headlines missed. If you're finding this helpful, imagine what you'll learn in my next video about the 5 exact words to say when police ask if you're carrying. Words that have saved permit holders from involuntary manslaughter charges in 3 recent cases. Subscribe so you don't miss it. Now, the part nobody is talking about, the enforcement gap. When a court orders a state to stop denying reciprocity, the state does not instantly retrain every sheriff, every traffic stop unit, and every court clerk. There is a lag. During that lag, which can last from 2 weeks to 3 months, police are still allowed to enforce the old law until a new rule is published. That means, first, you can still be arrested under the old rule if a cop does not know the order exists. Second, prosecutors can still charge you under the old statute, even after a court says the charge is illegal. They have to drop the case later, but the arrest, the mugshot, the bail, that happens first. Third, some small towns with no internet or old record-keeping systems may simply ignore the order until forced by a fine or a lawsuit. Here's the practical move you should make right now. Before you cross any state line next week, call the non-emergency number of the police department in the destination state. Ask, does your department currently enforce reciprocity with your home state after the recent Supreme Court opinion? Write down the name of the officer who answers. If they say we're waiting for state policy, assume you are at risk until a new state memo drops. Do not rely on the court order alone. Local departments do not always read federal rulings overnight. I learned this the hard way after a friend got pulled over in a border county in Tennessee last year. The deputy arrested him for unlicensed carry, even though reciprocity existed on paper. The deputy's manual still had the old page open. The case got dismissed 2 months later, but my friend spent 36 hours in a cell because he assumed the law changed the moment the court said so. Here is what most people get wrong. They think a Supreme Court opinion automatically changes every police radio in the country the same day. It does not. The change is legal. The enforcement is human. Humans are slow. Humans make mistakes. Until your local department updates its training, you are exposed. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the 50,000 gun owners who get these updates first. Click subscribe. The third layer is the 2026 deadline everyone is glitching on. The Supreme Court did not set a calendar date, but the practical deadline comes from state budgets and legislative sessions. Most states must pass a new reciprocity rule or accept a court order before their fiscal year ends in September 2026, or they lose federal grant money tied to criminal justice compliance. That is when the pressure turns from courts into politics. Governments hate paying fines, so expect a wave of rush legislation in early 2026. States will try to legally replicate what the courts already forced them to do, hoping to control the timing instead of having judges dictate it. If you live in a state that has hinted at reviewing reciprocity for 2026, that is not a promise. It is a delay tactic. The court order does not wait for a bill number. By the time a governor signs a reciprocity law in March 2026, dozens of permit holders have already been arrested under the old rule. Those arrests will still have to be dropped, but the damage, the time, the fees, the stress is real. So the overhaul the title talks about is not a future plan. It is already happening through courts. The 2026 date is when states try to clean up the mess behind the scenes, not when the protection begins. Now, here is the part that shocked me when I first saw the draft opinion. The majority used language from the Miller and Heller cases, the same ones that established home protection. They argued that denying out-of-state carry is equivalent to denying home protection when you leave your house. They wrote that the right is not tied to a fixed address. It travels with the person, not the postcode. That is a massive shift in how the court views the Second Amendment. It turns a local right into a mobile right without changing a single word of the Constitution. If that logic holds, any state that refuses to honor your permit is treating you as a second-class citizen under the right to bear arms. That is why the ruling feels like it shattered the old system. It reinterpreted the old text so that what was once optional becomes mandatory when it conflicts with historical tradition. Imagine you are a permit holder from a tiny state and you drive to a megacity 200 miles away. The megacity must show that in 1790 or 1850, They had a law saying they do not accept permits from small states. They cannot. Therefore, the denial falls. You're now legally armed there. The right traveled with you. Join the 65,000 gun owners who trust this channel for no BS legal updates. Hit subscribe and become part of the community. Update your address with your home state licensing agency now. Save the PDF of the Supreme Court order. Map out the exact date each state's court order took effect, and document every stop where your permit is questioned. Talk to a local attorney in the destination state once. This information could literally expire after January 2026. Subscribe now because the next video explains exactly what you need to do before that deadline hits. Here's the bottom line. The court removed the legal excuse for states to ignore your existing permit. If you have a valid permit today, you are legally allowed to carry in nearly every other state the moment a court order drops. Even if the local police do not post a sign about it for weeks, the right moved. The paperwork did not. Your job now is to close the gap between the law on the page and the officer on the road. Do that, and the overhaul stops being a threat and becomes protection. If this saved you from guessing, share it with one friend who still thinks reciprocity is political. Knowledge like this is the only thing that keeps the Second Amendment from becoming a local option again. Hit subscribe, turn on notifications, and stay ahead of the next rule that changes before the headlines catch up. Legal disclaimer, I'm not your lawyer. These are explanations of public rulings. Your state may have unique rules. Local enforcement can vary. Talk to a licensed attorney in your jurisdiction before making carry plans that put you at risk.